everything that he had put in the written motion.
Okay. Anything else from the state?
Judge, just regard to the last part, again, regardless of what we're calling it, these pieces of evidence that I offered at that hearing to show them every single thing that I had and intended to introduce that would go before the jury. They deliberately decided not to look at that, and I believe during trial articulated to the court that that is their common practice because they don't like to look at something, say that they have reviewed it, and then later something that maybe they did not see was introduced. And that's their practice, and that's fine. But I've listed everything in discovery. I've did an exhibit list that outlined everything. I left it in the courtroom, and I offered weeks before this to walk them through every single piece of evidence that I intended to introduce. They had copies of it. They were aware of it. I don't know what else I could have done.
Okay.
Your Honor, I can reply to that, please.
Okay. Last thing, because we've gone back and forth, which is
well, it's our motion that
do, but go ahead.
Just for the record, it's our motion. We made the initial argument. They responded. I would want to reply, if the court will allow.
Well, I was allowing him to respond to the ora tennis addendum, which was not included in the motion. So if you want to reply to that only, yes, then you may. I think I've heard enough already about the other issues.
Understood, Your Honor. The standard practice that I explained on the record is this, that the government under 3.220 has an obligation to list and provide all items of discovery. As a matter of practice, when a prosecutor says, hey, come and take a look at our file, I decline to do that because it opens up an opportunity for a prosecutor to say, well, it was in my file. You would have seen it, but you didn't look at it. So this was not a situation of us being dilatory or us trying to be willfully ignorant. We said, anything that you have, provide it to us so that there is a receipt, so that there's a record that we know that we have it. As for these demonstrative evidence, it would have been as easy as Mr. Cooper loading it into an email and sending it to us. The government chose to wait for these, what were initially introduced as demonstrative exhibits, to wait to provide those to us. That is not the right way to do it. And it's not right to say that somehow we didn't because we chose to not physically go to their office and look through their file for the reasons that I had explained. As for the notes, I still don't think the government has articulated how a note from 18 months prior, when they moved to introduce it to the court without telling the court that the note was so old. Remember, they had the phone, so if we're talking about looking at evidence, they could have looked at their own evidence, the phone that was in their possession, and said, hey, we're trying to move into evidence a note that is years before any of this incident, but they didn't look at that. It was only because we shared that with the court. I think for that reason alone, that it would mandate a new trial. As for the demonstratives, I've made my argument. Thank you for allowing me to reply.
All right, thank you so much. All right, well, of course, the 4 issues raised in the motion were all addressed during the course of the trial. Objections were raised by counsel. The court heard the argument from the parties and ruled on them. So that none of this is new that I hadn't heard before. But having considered the motion in its totality and, of course, having sat through the trial, at this time I'm going to deny the motion for new trial. All right, that said, I know we were originally scheduled for sentencing this week. At the request of counsel, we are postponing that. I know the PSI for both Mr. Whitaker and Mr. Robinson have been prepared and I think were distributed to counsel last month at some point on the 24th or 25th of August, something around there. So let's go ahead and pick a date and time certain on which you can come back for a sentencing in this matter. Because normally we do sentencing some 30 days after trial. We're now at the 6-week mark, having picked this week for everyone's convenience. So let's try to find a time, if we can, this month to return for sentencing. So as you know, here in our jurisdiction, we have every week is a trial week. So I don't know what trials I have going or not going. So, and I don't know how long they are to last. But if I'm to do a date, time certain to accommodate, and I do this for other cases that I have out-of-town counsel who need to travel, Friday is the best day I can do because we pick juries every Monday and then we try a case, and if it's a 2 or 3 or 4 day trial, that has less opportunity to impact on a Friday. So if you have Fridays available, I have every Friday this month available, and Fridays into the beginning of October, then we get a little dicey.
Your Honor, if it's Fridays, and I can explain the reason why, the only date, and I don't know if Ms. Quas is available, will be the 19th. On the 25th, I have a sentencing before Judge Williams. It's a plea sentencing, and that is at 3 o'clock in the afternoon. That would be a really tight window to get to Your Honor.
19th works for me. Does it work for the state?
Judge, I'll make it work.
And we don't know about Whitaker, but we'll inquire of Ms. Schlacks to see if she can come on that day. But even if she can't, there's nothing to say we can't have separate sentencings, even though that would make victim's family have to come twice. They're entitled to be heard. So if that works, we don't need to really talk about other dates. But what time? I don't know if y'all are driving or if you're flying. I have all
Your Honor.
available from 9 a.m. to 5 p.m.
So I would ask for the morning because I have a special set deposition on the afternoon of the 19th, but it's by Zoom. So even if I'm still in Jacksonville, I can make accommodations to conduct that deposition. So if we can do the morning, that would be the request that I would make.
I can do the morning. Do you want right at 9 a.m.?
I'm open. So whatever everyone else, yeah.
Are you trying to catch an early flight Friday morning? Are you coming Thursday? I mean, I can do it at 10. I can do it at 11, whatever accommodates.
If we could do 10 on Friday, Your Honor, that would work.
Okay.
That's
Mr.
fine.
Trooper, that works for the state?
Yes, Judge.
Okay, then we'll do September 19, 10 a.m. for sentencing, and how long do we think that will take? How many folks are you going to present?
Judge, I think I may have 2 statements, 15 minutes
Okay.
most.
And from the defense?
I think we could complete it within a half hour.
Okay. All right, then we'll schedule it for 10 a.m. on Friday, September 19th. The other case will just travel along to pretrial conference on that date. And anything else we need to take up from the state?
No, ma'am.
Anything else we need to take up from the defense?
No, Your Honor.
Okay, then we are in recess in this matter. Thank you.
Thank you, Your Honor.
I'm sorry? Oh, that's right. We're not in recess. Never mind. Sorry. We need to, Mr. Williams back. Okay. All right, we're back on the record in the matter of Mr. Dirk Williams, case 23 CF 207. Yes, sir, Mr. Williams?
Hey, the lady downstairs, the clerk of court said I only owe $139, and so may you pass it the next week, please?